And yes, well, it's always great to have staff. They're the ones that drive all this and make it happen. Let's start with introductions. I'm Michael Key. I'm a juvenile court judge from Troup County, Georgia, and I've served on the commission for, I think, a couple of decades. So Elaine, let's go around your way.
Okay, Elaine Johnson, I'm the Executive Program Manager, staff to the Child Support Commission.
Good morning, I'm Noelle Alvarez, I work for the Deviation Counsel, AMC, and I'm the staff attorney to the Child Support.
Good morning, I'm Ben Land. I'm a judge on the Georgia Court of Appeals, and I am brand new to this commission.
Roger Tutterow, Kennesaw State University, economics professor, and I've served since the mid-2000s.
Chuck Clay, Marietta lawyer. I guess like Roger, maybe you two been here since the beginning.
Beginning of time.
Why they still have me, I don't know, but I'm glad to be here.
Historical perspective, so.
And we'll talk about it.
Time.
In the back, Latanya Lawrence, I'm the program coordinator for the Child Support.
All right, let's recognize our commissioners on the participating by Zoom, and then we'll have our guests introduce themselves. So I don't know, no particular order. But Judge Williford, go ahead and introduce yourself if you will.
Good morning. I'm Connie Williford. I'm Superior Court Judge in the Macon Judicial Circuit.
And this is a good time to announce that as chair, I've exercised my discretion and have asked Judge Williford to serve as vice chair of the commission. She has agreed to serve as vice chair. Doesn't mean I'm leaving.
Hey,
unless the
TikTok.
governor tells me to, but we have not had one since I've been chair, and I appreciate her agreeing to do that. I know her plate is very full already, but she made a little bit more room for us. Appreciate that.
Thank you. I'm honored.
And anyone who would just jump in if you're on Zoom.
I'm Judge Emory Palmer from the Coweta Judicial Circuit.
One of my superior court judges.
I'm Brian Strickland, state senator, and in my day job, I'm an attorney in Magana.
Thank you for being here.
Morning, everyone. My name is Changwook Lee. I served as a judicial officer in Fulton County under Judge Farmer, Kevin Farmer.
Good morning, I'm Katie Connell. I've been on the commission, I don't know, since the beginning of time, it feels like. I'm a practicing family law attorney in Atlanta and co-chair the Statute Review Committee with Judge Williford. To the chair, I'm sorry, but I'm gonna take a moment and just let you know, I'm gonna be hopping on and off this meeting. I apologize, but I've got engineers at my house and talking to me about plumbing and beams and structure that I have to hear about. So if I pop off for a few minutes, I sincerely apologize to everyone, but I will come back.
We understand. Thank you. Representative Gaines.
Hey there, Houston Gaines here. Sorry, apparently, Judge, y'all sent us the rain over to Athens. So it's pouring. But anyway, I hope all is well. Houston Gaines been on this commission for a couple of years, or I think about a year and a half at this point, and in the legislature, my 5th year in the House out of the Athens area.
Representative Hitchens, you with us? Hi. Introduce yourself, please, while we wait on Representative Hitchens.
Holly,
All right.
she may not hear.
Does that get everyone? Ryan?
I'm sorry, I'm here. Good morning. Holly, Deputy Legislative Counsel with the Georgia General Assembly, here to help.
Thank you. Ryan? Bradley?
Hey, good morning. This is Ryan Bradley. I'm the supervisor of the DCSS Policy and Paternity Unit. I help out where I can. Happy Friday.
Thank you. Let's try Representative Hitchens one more time. You there, sir? Right, we'll circle back when we finish our again. So let's go around and welcome our guests. If you identify yourselves, please.
I guess I'll start.
Certainly.
My name is Brian Ellis, devoted father, just looking for some change. No problem.
I'm Jill Sapp. I'm from Savannah, Georgia, and I'm here regarding the HB 499.
Kim Gruber from Savannah, and I'm along with Jill.
All right. Second row.
Alicia Lipstone, Public Affairs Specialist, Social Security Administration.
I am Mara Block. I'm formerly with Atlanta Legal Aid. Now I'm with a private law firm called Deviation Law Firm out of Savannah, Georgia. And I'm here today to talk about HB 499.
Charlie Bliss, I'm the Director of Advocacy at Atlanta Legal Aid.
I'm Bradley Green with DFACS Medicaid here also for the discussion of House Bill 499.
All right, thank you all. And one more time, Representative Hitchens, are you with us? Text him, someone has. Is that, we still have 8 as the quorum? Quorum?
We've 9.
9, okay. So,
Including you.
yeah, okay. Perfect. All right, thank you all. The next order of business, I'm delighted to do this. One of my neighbors to the south, Judge Land has introduced himself. He's a new member, not quite a member yet. So, sir, if you will stand, I will administer the oath. All right. Read, you can swear or affirm as you choose at the end. So, I do solemnly swear to discharge all the duties lawfully required of me as a member of the Georgia Child Court Commission to the best of my ability and understanding. I do further solemnly swear or affirm that I am not the holder of any unaccounted for public money due to the state or any political subdivision or authority thereof. That I am not the holder of any office of trust under the government of the United States, any other state, or any foreign state which I am prohibited from holding by the laws of the state of Georgia. And I am otherwise qualified to hold said office according to the Constitution of the United States and the laws of Georgia. And I will support the Constitution of the United States and of this state. I so swear. Thank you, sir. Welcome aboard. Thank you.
And if you will, I'm Elaine Johnson. By the way. Yes, I'm gonna take care of the next.
Okay, thank you. Happy to be here.
No, all right, fine. All right, Ms. Horner, would you share our kind of rules with us, how we're going to operate today?
Yes, thank you, Judge Keith. And good morning, everyone. I'm Lieutenant Lawrence and I'm the coordinator for the Child Support Commission. And I will briefly discuss who will help us navigate the meeting today. We have our Zoom webinar. The Child Support Commission members and staff are designated as panelists within Zoom and can speak at any time during this meeting. All other participants are designated as attendees and are muted during the meeting, but may type a message in the Zoom chat and feature if you're going by the meeting. Also, anyone wishing to give public comment on speaking today may do so at the end of the meeting after the completion of our agenda. Please state if we'd like to give public comments by taking your request in the chat or in person. Please state if you'd like to give a public comment. Once you're called upon, you may unmute your audio, or if you're joining it virtually. Our chair, Judge Key, will make the determination on how many minutes you are allowed to speak. In conclusion of today's meeting, staff will post this recording on our YouTube channel, Georgia Child Support Commission. I will place the YouTube channel in our chat for everyone. Thank you, and I'll turn it back over to Judge Key.
All right, thank you very much. Next order of business is review and approval of minutes from our May 2nd meetings. They were distributed to all members of the commission. Do we have any additions or corrections? Okay, hearing none, the minutes are approved as distributed. We move next to the business of the commission subcommittee reports, and I will call on Dr. Roger Tutterow.
Thank you, Judge Keys. I wanted to appreciate the support of staff over the last couple of months as we continue to wrap forward with our Economic Study Committee. A little point of clarification, what the Economic Study Committee studies effectively are 2 things: the child support tables themselves, and then of course we oversee the selection of a sample for a analysis that is done to see how well we're actually performing as a state, which is of course required, I think, by the federal statute. The Economic Study Committee began discussing back in, I think, 2021, the issue of whether we needed to revisit re-estimating tables that we use for the presumptive award on child support. The original tables were based upon analysis in 2006. So we made the decision, recognizing how the world has changed in those ensuing time, to have Dr. Jane Venor estimate new tables for us. She provided that analysis to us, and we distributed previously on August 8th, 2022. So the Economic Subcommittee met several times, most recently June 21st and July 22nd, and brings forward a recommendation today for the adoption of the Rothbard base tables. For those that have followed this for a while, you know that the Rothbard was one of the components that went into the establishment of the tables in 2006. It is now clearly the most commonly used methodology. I think it's like 32, 33 states in the union use Rothbard. So we'll be bringing us in compliance methodologically. The only other change that we made was we will now calculate awards up to, I believe it's $40,000 per month, as opposed to previously the cap was at 30,000. So that, of course, is recognizing it over time as inflation has come up. We're kind of pushing that target up as well. So after our discussion that we had on July the 26th, we came forward with a motion to adopt the Rothbard tables as distributed.
Being a motion from a standing committee, it does not require a second. Is that correct? Yeah.
We need a motion.
But if we think so, yeah, let's get a motion in a second.
Move to approve the recommendation of civil.
Is there a second?
I'll second.
Thank you. Any discussion or questions on the commission? All in favor, say aye.
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 Any opposed? Any abstentions? Motion carries. Thank you so much for you and all the members of your committee. That was a lot of work. We very much appreciate it. How many times have you done this now, Dr. Tutterow?
I'm afraid to count. So, thank you.
Very important piece of work. We move next to our statute review subcommittee. Our co-chairs, Katie Connell and Judge Williford.
All right, the subcommittee has continued to work with Dr. Jane Venor for the Center for Policy and Research, Inc., in exploring solutions for the low income and the parenting time deviations. The subcommittee is making great progress on both subjects and has more scheduled meetings on August 18th at 1:30 p.m. and September 21st at 10 a.m., during which some final decisions will be made. We've met several times with Dr. Venor, and we're getting very close to a point where we would have some recommendations to make to the full commission, hopefully at our next meeting. We also had discussed, you may remember previously, meeting with Senator Strickland, who chairs the Senate Judiciary Committee, and he's willing to convene meetings on the topic as needed. The topics, but particularly we were, Katie and I co-chair the parenting time issue, and we wanted to have some work done on that with the legislature in advance of next legislative session. We are very close to being able to have a recommendation so that we can actually sit down, hopefully Katie and I, with some of the staff, with Senator Strickland, to discuss those things, and hope to have that done probably within the next month, if we can make that work. Katie, do you need to add anything regarding the parenting time work?
No, Judge, thank you.
All right. Judge Palmer, would you like to speak regarding the work on the low income deviation?
I'll just echo what you said. I mean, we're approaching the point where we're going to have something to, something concrete. And we've done a lot of work on it.
All right.
Any commission members have questions of the chairs of the committee or staff?
I just want to let y'all know that Mr. Bill Hitchens said that he is on. We just can't hear him.
Okay.
He's muted. If he could unmute.
Okay, so. Yes.
I will take a moment to say that there is some, at least for me, straining to hear some of you there. And I've noticed in the chat, there's been some comments about being very hard to hear. So, Judge Key, I can hear you just fine, but just make sure, if you will, that you're speaking into the microphone.
And the microphones are overhead, so everyone will just need to speak up.
Okay, yes.
And that might be helpful. But
Well,
thank
and just use your outside voices maybe, but because we are straining to hear some of you.
Except when addressing the chair. Just kidding. I know Judge Colbert, one of our commission members has joined on. Judge Colbert, please introduce yourself. You're muted, Judge Colbert.
Good morning. Good morning. I'm Judge Lisa Goldwater Colbert. I am a Superior Court Judge in Chatham County. Sorry for my tardiness, having technical difficulties as usual. Thank you.
Yeah, thank you, Judge Colbert. It's always good to see you. We'll miss you in the juvenile courts. Okay. And Ms. Mewborn, could you introduce yourself, please?
Good morning. I am Melinda Mewburn with the Division of Family and Children's Services. I am a policy specialist with the TANF program, Temporary Assistance to Needy Families.
All right, thank you very much. And on the Statute Review Committee, there are no action items specifically at this point, although they're related to a subsequent or to an action item later on the agenda. So Technology and Calculator Subcommittee.
Okay, that will be me because our chair, Regina Quick, is unable to be with us today. So I'm and this will be very short. Luckily, our child support calculator is running very smoothly. We're not having any kind of technical issues. Our IT department at the Judicial Council, Administrative Office of the Courts, does a fantastic job of making sure that it is a secure application. And typically when I hear from someone with a technical report, it's actually a user issue and I contact them and handle that very quickly. And we are still looking at how we can improve the calculator and its appearance and its functionality. That's something we'll continually always do to simplify. It's important though to note that everything the calculator is based upon and everything it does must come from the statute. So sometimes I have folks contact me and say, well, I wish it would work this way. And I will say, well, the law says it has to do this. So we have to do what the law says. But everything's running smoothly with our calculator at this point. We did have an update earlier this year that we have annually for Schedule B. And but we're in good shape there. And we'll stay in touch with Ms. Quick about any future meetings for that subcommittee. We have nothing scheduled at this time.
Thank you, Elaine.
Thank you.
Once again, I want to thank the members of these committees. That's where the real work is done, is in committees. And I know how hard that work is. I was chair of the Statute Review Committee myself for a long time before I became chair of the commission. And I will say that when I talked to Judge Williford about being vice chair, her first experience, I think, big experience as a committee member was on Statute Review Committee, and they worked really hard. It kind of scared her that that's always a level of work. And I will say that I don't think the entire time I was chair of Statute Review Committee, we had as much work to do as our current committee staff. So thank all of our committee chairs and the members of your commissions, both those on the commission and those who are not on the commission, for the hard work that you do. I want to take one item out of business, out of order. We have a couple of our commission members that may have to leave a little bit early, and I don't know how long the discussion on 4 down and 9 is going to take. So on item 4A is discussion of a bill or bills. We know that the basic child support obligation tables are ready to go, and we'll need some legislation drafted to facilitate that. We also know that we're getting close on some of these other potential bills. So at this point, we're asking for a vote authorizing or requesting our legislative members to authorize Holly to actually draft those bills for us and do that work. Is that the motion that we need? Have a second?
Second.
Thank you. Any further discussion about that? If we have any volunteers that are at the meeting today that want to jump in and authorize her to, once this passes, then that would be great so we can get started. But all in favor of the motion, say aye.
Aye.
Any opposed? Any opposed, say nay. Any abstentions? All right. one of our legislative members would be bold enough to authorize Holly to do that, we would appreciate it.
Judge, I can do that.
Thank you, Senator Strickland. All right, Holly, I think that does it. I think you have your marching orders to work with us then. Thank you so much. Now we'll, those are the only votes we have today, right? That is right. All right, let's go back then to discussion on HB 499. We have a lot of people here to speak to that bill. Do we have an order? How do we want to have this?
Yes, sir. Actually, we're going to start with Noelle, and she's going to give us some background and then move to me, and we'll move to some other speakers.
Thank you, Noelle.
Yes, good morning again, everyone. Before we move to some of our subject matter experts and other guests who are joining us today, I just wanted to take a moment and refresh recollection on House Bill 499, which was filed this past legislative session. That bill proposed to extend the duration of child support past the age of majority if the child was deemed to be disabled as defined by that bill. So the commission was unaware of the bill before it was filed in February 2023, but it's my understanding that the drafters had conferred with DHS. When I became aware of the bill in late February, I knew a number of commission members so they'd be aware of it. HB 499 did not cross over the Senate. It was sent back to committee on February 28th and remained there. While the bill was moving through the legislative process, it was briefly discussed during one of our statute review subcommittee meetings, and I gave an update on it. You may recall back at a full commission meeting on May 2nd, and it was just decided to keep I'm being told to speak loud, to keep it on our radar, so to speak. So since the last commission meeting, staff has been contacted by legal aid attorneys expressing grave concerns about HB 499, especially on low income families. And we felt duty bound to raise it to the commission for further consideration. So we extended invitations to attend this meeting. I say we, I don't need to say anything. He's done an enormous amount of work to get those to it. So Elaine extended invitations to attend this meeting to those sponsors, and we're fortunate to have, I think, at least one of them here with us today, Representative Bill Hitchens. We thank you for being with us, Representative Hitchens. Also, we have with us today Ms. Jill Sapp, who I understand is one of the catalysts for the bill, and she's women in red. And she came all the way up from the Savannah area, so thank you also for being with us today. Yet we also have several experts on government benefit programs here to share their knowledge with us. So with that brief summary as a background, I'll hand off the rest of the discussion to Elaine.
Thank you, Noelle. Okay. So as a result of those inquiries that Noelle just mentioned, and she mentioned the fact that we did some work on this, we needed to become more familiar. So we started looking for answers on what would the impact be, positive or negative. Specifically to subsection E, and there's also a definition piece in the bill. And we collaborated with the Division of Child Support Services, Erica Thornton in particular, and she helped us identify the subject matter experts that we've been talking to and are here today to discuss with us any pros or cons that they might see on the different benefits, specifically Social Security Administration, supplemental security insurance, income rather, Medicaid, SNAP, and TANF. And we also have Mara Block, who will talk to us from formerly from the Atlanta Legal Aid Society about concerns with low-income families, impact there. And we had a meeting in late June with all these individuals so that we could learn more and understand more about what's involved in the process. Looking at the resources that we had available to us and trying to make sure we understood clearly what services are available, how would they be impacted when there's additional income added to the budget. There is a budget that is done for each one of these services, and we want to make sure that we knew what that impact would be. So we, as staff, we had thought about some things that we wanted to make sure that we know and that we want the commission to think about. First question is, how would any support received from the other parent affect the eligibility of the adult disabled person to receive services from each of these programs? What would the impact be? This is the second thought we had. What would the impact be for each service if support is ordered and included in the budget, but not paid by the other parent? And then, of course, an additional question would be, who would bring an enforcement action if that money is not paid? Would the disabled person have to bring that action, paying attorney's fees and so forth involved? And we want to make sure that these are things that are thought about in this process. So we do have our subject matter experts, and I want to call on some of them we have in person, and we're really thankful for that. And some we have on Zoom, and we appreciate everyone who's participating. And these folks have certainly given up their time individually. They have been a great little group of people to talk with and work with and learn from. And we appreciate their being here today, willing to talk with the commission, educate each of you, make sure that there's good discussion. So we have Alicia Lipscomb, who's with the Social Security Administration. And let's see.
I think we sit at this table up here, maybe.
Yeah. Is Alicia here?
Yeah.
Sorry. I'm so sorry.
Hey, could you come sit at the table
Would you,
here?
yeah, join us, and that way we can hear you on the microphone. We hope a little bit better. I apologize.
No problem, no problem.
And someone on Zoom will let us know that this works better than what we've been doing. We'd appreciate it.
Yeah.
Good morning, everyone. I can be loud, I'm a mom. I yell at my kids this morning to get on the bus or in the rain, so. Good morning,
Brian,
everyone.
can you all hear Brian?
We're good?
Okay.
Awesome, great. Well, good
Perfect.
morning, everybody. Thank you so much for inviting Social Security to come and speak to you about supplemental security income. A lot of people often get this confused with Social Security disability. Supplemental security income is a program administered by Social Security. We federalized it back in 1973, just to give you some perspective. Each state ran their own version of this program. It provides monthly payments to adults and children, with a disability who have income and resources below specific financial limits. So it's a low income program for adults and children who have meet specific financial limits. The program is intended to support individuals with limited or no work history. A person could have never worked a day in their life, never paid Social Security taxes, as long as you meet the specific financial requirements and found to be disabled per the Social Security Act, they would be eligible for this program. Supplemental security income payments are paid from general federal tax dollars. They are not paid from Social Security taxes. And that's why there are the specific financial limits tied to it. One good tip to always remember when somebody receives supplemental security income, they receive benefits on the first day of the month. That's always a good tip to know. Social Security disability and disabled adult child benefits, which is paid to a child of a parent receiving retirement or disability benefits, who's found to be disabled before the age of 22, is financed through regular Social Security taxes. So that's a different requirement there, where the parent had worked on behalf of the dependent child. So by their tax contributions, this child will be eligible for up to 50% of the worker's 100%.
Did you realize you can call the police and accuse
so that
anyone
can be a higher income amount versus the specific supplemental security income benefits. Just to let you know, the most an individual can receive from supplemental security income in 2023 is $914 is the limit this year, $914. If the person meets the requirements.
That's every month?
Yes, sir.
Okay.
Every month, $914 is the most that somebody can receive. States in the South do not offer what is called a state supplement. Certain states do finance that, such as California, New Jersey, Rhode Island, a couple of other states, but they're slowly whittling that down over time. We're seeing a change there. The key part why a lot of parents of disabled children look at supplemental security income is when a person is considered a child per the Social Security Act, they're under the age of 18. The month after the child turns 18, they're a child, adult per our rule, no longer a child. They can still be in full-time enrollment in school. It's the fact that they're the month after they turn age 18. And the month after a person turns age 18, they're considered adult. So their parents' income and resources no longer count. So the parent may have previously filed for benefits for that child, but were denied technically due to their income and resources. We always look at income and resources first before we even go through a disability decision. And a lot of parents of special needs children have gone through this process in order to get denied by us technically in order to file for Katie Beckett Medicaid. Because the health insurance is the most important part with this program, because as long as you receive $1 or more of supplemental security income, you're automatically enrolled into Medicaid per your state of residence. It's an automatic enrollment as long as you receive $1 or more. And that is the key part there. dollar or more, you have the Medicaid coverage, which is critical for a lot of our special needs recipients to receive the services they need. And a lot of people often get Medicaid and Medicare confused. Medicare is tied to an individual's receiving disabled adult child benefits from the parent. And those individuals receive their benefits on the 3rd or Wednesdays of a month. I like to give that distinction so you understand the two different programs, because we have a tendency to mix the two. And remember, the coverage that Medicare provides and Medicaid provides vary. Medicaid is state by state, Medicare is per the federal statutes of what is provided where you live. Another factor they look at is the resources. We look at income first, resources second. Resources are anything you convert into cash. Excuse me. The individual must have less than $2,000 on the first day of the month in their name in order to be eligible for supplemental security income benefits. So if I have a bank account, I have a child with special needs, it is their account with their name on it. If there's more than $2,000 the first day of the month, they are not eligible for supplemental security income that month. Just to help you understand that. So remember, under the age of 18, parents' income and resources do count which parent they're residing in. Another question we have to ask is the child receiving any income? If the child's under the age 18 and receiving child support, that is income for the child. And per our rules, when a person is under the age of 18, they're considered a child. We only count 2/3 of the monthly child support received against the monthly benefit. So if I have a child currently getting $914 and they receive $600 in child support this month, we'll count 2/3 of it. So let me do the math here, break it out here. I had it in my head. Sorry. At 900, okay, let's say the child's getting 900, I apologize. And I'll do it easy. I was doing multiplication and division with my child last night, so that was my math, to be honest. And so we're gonna count $600 of the child support. So we'll take $914 minus 600. And that's how much the child receives per month from supplemental security income. And they have to receive, remember, at least $1 more to maintain their Medicaid coverage. So let's transition to the child turning age 18 and older is now considered an adult. Once that transition occurs, that income is counted dollar for dollar. There is a transition there. So if the child is receiving more than $934 a month gross in child support payments, the disabled adult child, I should reference that. So they're older than the age of 18. We count that dollar for dollar. And if it's more than $934 gross a month this year, they would not be eligible for supplemental security income payments. Thus, their Medicaid would stop. Because we have a date exchange, when we show 0 payments, that tells that state that they're no longer eligible and they will stop the Medicaid coverage. And that's the key thing I do want to emphasize there. So I'm going to give you an example here to help you understand the impact on income, because not everything is so simple where the person only receives child support, there's no other income involved. So we're going to use an example where somebody's getting disabled adult child benefits. They're getting a benefit from a parent because they are receiving retirement benefits or disabled. And whenever they apply, we always inquire by law, do you have a child that had a disability that existed before the age of 22? It doesn't matter how the child is now, and they're currently unmarried. That's a big factor there, because if they're married to someone, they're dependent on their spouse, not their parents. So we always inquire about that. So I'm going to go through an example to help you understand how this could sort of create layers. It's not as simple. There's a lot of layers involved with this. So we got Mary. She is 24 years old. She currently receives Social Security disabled adult benefits of $720 a month and receives $214 in supplemental security income benefits. So payment on the 3rd, payment on the 1st is one way of thinking about it. She receives disabled adult child benefits because her mother is currently receiving $1,440 in disability benefits. So it's 50% of the mother's 100%. So she's received that now. In August of 2023, her mother, who is her represented payee, because Mary is unable to communicate, understand finances, so she represents herself to Social Security. The mother does on behalf of her. The VA uses the term fiduciary, but we at Social Security use the term represented payee. It's not legally binding. You do not have to be power of attorney to do that, just to let you know. Reports that Mary received a child support payment, arrearage payment of $350. So it was intended for Mary, $350 in July of 2023, and will continue to receive that amount per month. So if as I mentioned before, the person's combined unearned income, they're not working for it. So the disabled adult child benefits unearned and the child support is unearned is greater than $934. Remember, Mary would no longer be eligible. So we would take the $720 she receives in disabled adult child benefits. That's her first form of unearned income. Then we're going to add the child support payment of $350. Her total income now be $1,070. Since that's greater than $934, she will no longer be eligible for supplemental security income. And thus her Medicaid would stop. And oftentimes it takes about a month or two, but it would stop in relation to that because there is a date exchange. And if a person does not receive payment for more than 12 consecutive months, because we know child support can be up and down, we see it all the time, up and down reporting that. But the person is ineligible for more than 12 consecutive months, the benefits will terminate. What I mean by terminate is that they would have to go through the whole disability claims process again in order to be found disabled, in order to get the health insurance coverage. We just can't flip the switch and turn it back on. They would have to go through the whole claims process again and be found disabled per the Social Security Act before any benefits can be reinstated. And on average right now in the state of Georgia, it is taking 8 to 10 months, just to let you know, for initial claims decision through disability determination services, which is under Georgia Voc Rehab. They're the parent agency, because we contract with each state to make the medical decision. So right now it is 8 to 10 months right now in the state of Georgia, just to give you some perspective on the timeframes there. Another point I want to bring up is Social Security does not receive real-time data, such as child support or income. We don't get real-time data. We are dependent on the representative pay or the individuals who self-report their child support or any other income. It is in the person's reporting responsibilities. Often representative payees or individuals do fail to report child support timely. We ask you to report your whatever income you receive no later than the 7th day of the month, so we can calculate it correctly. And if a person fails to do that, it will result in an overpayment. So to go back to Mary, remember I mentioned her mom reported in August, but she got it in July. As a result of that, Mary owes $428 to the Social Security Administration. Since she's getting disabled adult child benefits, we will go back and recoup those funds from her monthly disabled adult child benefits. So her debt is down to 0. And we do not, we usually receive overpayments. We usually take them in one fell swoop. You would have to go through a whole waiver process in order to lower that amount, in order for us to recoup, because these are general federal tax dollars. So they want to recoup those for the Treasury Department. And we conduct income, resource, or medical reviews for supplemental security recipients every 1 to 5 years, depending on their medical profiling or their profiling concerning income and resources. So oftentimes when we do these reviews, we find people that receive child support for minor children who never reported to us, and they can owe us funds going back 2 years. So we just want you to be aware of that. We do not get real-time data because we do not have access to a state data exchange regarding child support in the state of Georgia. So that just helps you understand how income affects benefits. But the key part is as long as the child receives $1 or more, they're going to be eligible for their Medicaid coverage. So that's how it goes hand in hand with those programs there. But we want to make the clear distinction between disabled adult child benefits and supplemental security income, because people have a tendency to lump the two together because it's just disability, an overarching umbrella, but it's all about funding and the coverage. People get Medicaid with supplemental security income, and with disabled adult child benefits, you don't get Medicare until you receive 24 months of payments. You have a 2-year waiting period before Medicare begins when you're a disabled adult child. So you can have a health insurance lull in between those two there. So I hope that was informative to help you understand income and supplemental security income.
Yes.
So that was a lot.
I know it was a lot.
Let's see if we have questions from commission members or staff, either one first.
Including on Zoom. Are there any questions?
I have a question. The SSI, how long does that last? I mean, if you continue to be disabled, well, let me back that up. Could you, for instance, let's say you're 65 and you're not eligible for Social Security retirement because you didn't pay in. Would you then be eligible for SSI, or do you have to prove that you're disabled?
That's a good question, Judge Williford. Well, with supplemental security income, we also have another category called supplemental security income aged benefits. And that applies to people age 65 or older U.S. citizens who meet the specific financial requirements.
The same resources.
Yes,
In other words, if they owned a house or a car or something, it might put them over the resource limit.
It's a home that they do not reside in or property they do not reside on. It would be over that $2,000 limit. Deeded property is another thing we're running into a lot, where if somebody got an inheritance, they split land. If it's more than $2,000 a month, you're not eligible. Oftentimes you run into situations with disabled adult children. They have well-meaning grandparents. They used to love the savings bonds, and they show up. It is in the child's name. And if it's the combined amount, again, with all resources in the child's name, is more than $2,000 the first day of the month, the child would no longer be eligible.
Thank you.
Any other questions? David?
I have a question. Can I just ask sort of a summary question to make sure I heard this correctly? Is it fair to say that providing child support to a disabled adult could negatively impact their ability to have health insurance coverage through Medicaid? And is that what I heard you say?
If the person is no longer going to be eligible for a monthly cash payment for federal statutes, their Medicaid will terminate.
So we could have basically a very well-intentioned law that requires parents to provide support for their children who are disabled beyond majority, that results in no health insurance coverage for those same children.
Is that a question?
That's a question.
They would not be eligible if their income was over them, because I can't comment on, I just have to state the rules.
Yeah, sorry, that's fair. Okay, thank you.
I can understand, you just want to get clarification, because a lot of people often, supplemental security income is an arena that people are not aware of. Usually parents of special needs children have experienced it. And usually they experienced it when the child was younger and they were denied due to their own income and resources. So they did not deal with the actual monthly benefits and dealing with that, because they usually would go through the Katie Beckett Medicaid Beamer waiver. They would go that route. But as people are transitioning to age 18 and older, when we attend the school transition fairs for the special needs and special education departments, that is one of the most important topics to those parents. If I become eligible, my child becomes eligible, what type of health insurance coverage comes with it? That is the question we get automatically at these events.
Actually, this is your bill, so I'm going to give you the opportunity to ask questions and take advantage of this opportunity if you want to. Do you have any questions?
He's muted.
And you're muted again, Representative.
Can you hear me now?
We can now. Yes, sir.
Hear you now.
Yes, sir.
Okay, I'm sorry for all the audio problems, but I've been listening pretty intently, and you know, I got into this. This is somewhat out of my bailiwick. I know Mrs. Sapp. I know her mother, and I know her ex-husband. And when I became aware of this situation, I was just astounded at the inequity. Her husband is a multi-millionaire, and she has no training or ability to sustain herself, and has learned over the period of her divorce how to sell real estate. And he's just cut her off from everything. Won't talk to the child. He took the autistic child off his health insurance. He has things like therapy twice a week that cost him $70 previously, and now it's $500 each time. And it just seemed horribly inequitable. And I spoke with legislative counsel about drafting a bill. As I said, I had very little knowledge. I did think Mrs. Sapp was more aware of Social Security, and she may be, because her mother is a career Social Security retiree that worked in the Savannah office for many, many years. And but you know, I ran it through the first committee, and it passed unanimously, and because of the situation I just described. However, I soon got a call from the Department of Human Resources, and they tried to explain to me what was going on with regard to how it may affect other people. So I dropped it and we wanted to discuss it further and see if we couldn't come to some equitable solution. Now, I'm very aware that we have nothing to do with Social Security on the federal level, but I still seem somewhat disappointed that one parent can just walk off and leave somebody almost destitute while the other, the custodial parent has to live in a manner that she's very unaccustomed to. And you know, my belief is that the whole priority of the divorce process is the security of the child or the children. And I just don't think in this case it is equitable at all.
Thank you, Representative. Do you have any specific questions for Ms. Lipscomb?
Not really. I'm a novice on Social Security too. I know Ms. Sapp's mother is an expert, so I took for granted that she was pretty much aware of some of the criteria that would befall her if we got engaged in this.
All right. Thank you, sir. All right. And thank you, Ms. Lipscomb.
Oh, you're welcome. Thank you, guys.
Can I ask one question before we move on?
Yes.
And maybe this is outside of our wheelhouse. I'm just wondering if there's any other way other states have addressed this. Have other states considered a bill like this? And what I'm getting at is there any other creative way to set up an ability of a child to even have a benefit from a trust, or some other way that we could have a law where in this situation like we have that Chairman Hitchens is trying to address, where funds could be available for a child without affecting their eligibility? And maybe that's not something we can dive into today. I'm just curious if there's any creative ways to accomplish this goal outside of a child support order.
May I respond again?
Yes, sir.
Mrs. Sapp has done extensive research on this matter, and she has a list of other states that seem to have approved something similar. I'm not sure the exact legislation, but she's got a list of them, and I think she has them on her person in the room there today.
And we're going to hear from her certainly in just a little while.
And to address Mr. Strickland, every state has called what is it was a lot of it has called the stable account, STABLE. We had Social Security. It is not a countable resource. Up to $125,000 of that is not countable. And if you go to ablega.gov, it would still count as income the month the child gets it. But once it's put in the stable account, it's an excluded resource. So just to let you know, and that there's been a lot, we don't, of course, it's state by state, but we make sure parents are known that's an excludable resource. And also in terms of child support too, there is a couple of nuances with it about the rearage, who gets it. So there could be some situations where it isn't countable dollar for dollar, but we have to be we have to dig into it and see what it comes down to. And so that's probably something to be a little bit more nuanced, but I try to generalize it just across the top, what would occur with general income coming in to help people understand that when it comes to that. But the stable account has been, it's called Able Stable, so it goes back forth. That's been very helpful for individuals to know about that, because those funds from these stable accounts can be used for the individual's food, shelter, resources. It's been very important for parents planning for the long term. When they're no longer here, is there a resource that they can use to help support the child? So up to $125,000 is not countable. And that's been very beneficial to individuals. And it's ablega.gov is the website there.
There a restriction on where that money that goes into the stable account comes from?
We would look at if they receive it, it goes, it's income that month, resource the next month, but it's excluded. That's 125.
But it can come from any source. It can come from the parents or.
Mayor mentioned the savings bonds.
Okay.
They would cash them out, counts for income for that child that month, so they may not be eligible that month, but they deposit it and it's not counted the next. And remember, they need, as long as they have at least 1 month of payments every 12 months, that keeps their benefits going.
But that has to be volunteer, like money.
Yeah. So people do that.
right? But then there are cases that.
Yeah, Mr. Staff, you'll get, I'll let you talk in just a little while.
I'm sorry, yeah.
That's all right, that's fine. So as an example, if $30,000 of those funds were expended on benefit of a child during this calendar year, and on January 1st of next year, then that was replenished. Then that for that month, the child would lose the benefits, but they would not feel any
So
such.
you'd have to look at what was the income source.
So
We have children who are working on getting a benefit, so they count as wages that month. They put it in the stable account the next month. We see that too also. So it gives, from meeting with other individuals, parents or caregivers, they said it gives them a little bit of security, knowing that they can put up to $125,000 in there. And it would not affect the child's eligibility. If you come up to that with other resources, but the role is stable, it's up to $125,000 we don't count.
So if the judge had the authority to require that fund be created and replenished over a period of time, then it would just be that 1 month of each year.
I have to go back, to be honest, I haven't been a technician in a while with that. When this law came out, I can look into it. But the key part is it maybe counts income 1 month, but it's excluded the next month, up to $125,000.
Thank you. Any other questions? Thank you, we appreciate it.
Okay, you're welcome. Thank you guys so much. I appreciate it.
Thank you.
Thank you. And we're gonna hear next from Bradley Scott Green, who is with the Division of Child Support Services, DFACS, and he's gonna talk to us about a little bit more about Medicaid.
Morning again. My name is Bradley Green. I'm with the Division of Family and Children Services as a Medicaid policy director within the Department of Human Services. I'm going to give you a little bit of background in regards to Medicaid with defects because it's a little bit different in some terms than what SSI Medicaid would be. And I apologize if you already know any of these divisions for this background. We contract, when I say the Division of Family and Children Services and DHS contract with the Department of Community Health to determine eligibility for Medicaid classes of assistance. The classes of assistance in Medicaid that we work with are broken into two programs. One is referred to as Family Medicaid, and the other is regarded as ABD, Age Blind Disabled Medicaid. The majority of the family Medicaid classes of assistance, and there are several, and when we talk about classes of assistance for Medicaid with defects, there are about 30 plus total. When we talk about those for family Medicaid, most of them are what are referred to as Magi Medicaid because they're based on ADA law from 2014 and tax laws for modified adjusted gross income. That's the reason why they're referred to as Magi. They look to set up budget groups for who's tax dependent, who's a tax filer and such. ABD does not go on those rules. So in both of the programs, we're going to have several different rules that might be different from one program to the next. Excuse me. If we look at Magi Medicaid first, let's say the child is receiving in a class of assistance, and this could be anything for families or for the children. Parent caretaker Medicaid, very low income limit if the child might be there. Children under 19 or peach care for kids is where we would see most children for Magi Medicaid. The age limit for a child to receive in a Magi Medicaid, family Medicaid, Magi Medicaid class of assistance is 19. So with the rules that we have for budgeting, child support by Magi rules is considered not taxable. So therefore, in the Magi Medicaid budget, we would not include child support at all, period. So if this child happened to be receiving in parent caretaker, children under 19 or peach care for kids, at the age of 18, they turn 19, they're going to get, if they're under 19, excuse me, when they turn 18, they're going to continue for one more year. As long as the household meets eligibility for that Magi Medicaid class of assistance. We don't immediately have to move them to a Katie Beckett class of assistance, which is under ABD. They can still be there. However, if the child is needing particular extra services, special needs services, and if it's anything we might need to coordinate with DBHDD, then it might be more advantageous to move the child to the Katie Beckett ABD class of assistance. But if the child remains in Magi up until the age of 19, child support will not be counted at all. Magi Medicaid also does not count any resources. So if by some chance that stable account, for example, or any other account that might have been established for a child, if they were receiving Magi Medicaid, it would not count either. So that it's limited for 1 year when they go from ages 18 to 19, but certainly there's that extra year if the age is going to be moved beyond the age of 18. When we get to ABD classes of assistance, you have first Katie Beckett. That though goes only up to the age of 18 by our state policy. It's my understanding that the child support would count if it happened to go to the child, and by Medicaid rules for the state, child support being paid to the child is considered income to the child. The only income from child support that we would regard for the parents' income are arrearages. So if we find out that there is any amount in arrears that are being paid, we'd have to get clarification from the Division of Child Support Services to say how much were arrears. That would be on a line budget case for the household for the parent, and then regular child support payments would be for the child. In looking at the Katie Beckett, it's my understanding we do have the 1/3 exclusion for the Katie Beckett budget, if that happens to be regarded there for the child and received by the child. Once the child turns 18, though, they're going to lose that Katie Beckett coverage. And the procedure in our agency would be for that point is to refer the family to apply for SSI. If the child becomes eligible for another ABD class of assistance, let's say, and there again are several, but let's say they are eligible for that. At age 18, they pretty much are regarded as an adult, but we do have the disabled adult child class of assistance, which could cover some of those needs for a disabled child. However, it's my understanding as far as ABD budgeting goes, is that child support will be completely included. So what we look at as far as Medicaid through our agency, the effects would be non-existent if they were receiving a Magi class of assistance. But if they get into Katie Beckett, if they get into other ABD classes of assistance, then the potential is there for however much the child support monthly payment may be. It could have a negative impact on eligibility for those ABD classes of assistance. And again, in reference to that stable account and other accounts that people may have set up for persons, we also in Medicaid policy look at money that comes in, particularly with lump sum payments is where we see this a lot. It's where we do count it as income in the month received, but we can count it as a resource in the month thereafter. So when we look at resources, ABD will look at all resources. It's my understanding for that the stable account, particularly if such is set up, that one is completely excluded in ABD budget. But it all depends on what the resource is. There could be several. We have several listed on our policy manual. We just have to refer to and say, okay, it's this one. What is this one? They all may have different rules, and they all could have different rules based on what the class of assistance is. That's one of the challenges of working with 30+ classes of assistance with our agency, having to maintain many rules. So again, the impact, if it was Magi Medicaid, would not be at all, extending that at least going from age 18 to 19. And then receipt of the child care, child support, excuse me, for ABD though, looks like it could have a potential negative.
Any questions from commission members or staff? Anyone on Zoom? Representative Hitchens, do you have questions? You're muted again if you do.
I done mute again. I'm sorry. I don't have any questions. It's certainly a complicated process, that's for certain.
Thank you, sir. All right, thank you, Mr. Green. Appreciate it.
Sure, thank you.
Thank you. Okay, now we have Pamela Mack also with us, and she's on Zoom today. Hello, Pamela. And she can talk to us about, she's also from the Division of Family and Children's Services, DFACS, and she can talk to us about SNAP, which some of us may know as food stamps formerly, but that's the name of the program now. And there's Pamela. Thank you for joining us today, Pamela.
Thank you, Ms. Mack. You may proceed.
Good morning, and thank you for the opportunity to join virtually. I am Pamela Mack. I'm the SNAP Director for the state of Georgia. And as was just indicated, SNAP is formerly known as the Food Stamp Program. It is the Supplemental Nutrition Assistance Program that provides just that, a supplement to families in need who fall within certain income parameters. It provides a supplement to allow them to be able to purchase food and other items to assist in their family's needs. So SNAP eligibility is first determined by who is included in what we call the assistance unit, or who is included in the case, so to speak. And there are certain individuals that must be included together in a case when considering for SNAP eligibility. Those individuals include spouses, children under the age of 22, and other individuals that purchase and prepare meals together. So if you have an adult disabled child who may be above the age of 22, but if they purchase and prepare meals with their guardian or any other household member, then the policy requires that they be included in the case together. So for SNAP purposes, and like the other programs have already mentioned, there is their income requirement and determination that is used in determining eligibility. And in our budgeting process, our income is either determined to be earned income, which is either wages or self-employment as an example. And we have examples of unearned income, child support being one of those unearned income types. Child support is defined as income received from an absent parent for the support of his or her children. And for SNAP purposes, that income is included in our budget for eligibility determination. So there are no special no special policy or regulations regarding how to count or treat that income for SNAP purposes. If the individual included in the case is receiving that unearned income type, then it is factored and considered in their SNAP eligibility. Does not mean that the household would be ineligible. It just means that that income will determine how much, if any, benefits that the household will receive. Are there any questions?
Thank you, Ms. Mack. Any questions from Commissioner staff? All right. All right. Thank you very much for that information.
Thank you.
Ms. England is.
Yes, and we have Melinda Newborn with us, and I think she's also, there she is, okay. And she's also with the Division of Family and Children's Services, or DFACS, and she can speak with us about TANF, which is Temporary Assistance for Needy Families. And thank you, Melinda, for being with us.
Thank you, and thank you for this opportunity. I am Melinda Mewburn with the Division of Family and Children's Services, here to represent the TANF program, which stands for Temporary Assistance to Needy Families. It provides cash assistance to families with dependent children under the age of 18 and pregnant women for a limited time. To be eligible for TANF, families must meet both financial and non-financial requirements established in state law. For example, applicants must be residents of Georgia. Children under age 7 must comply with TANF immunization requirements, and children ages 6 to 17 must attend school and have satisfactory attendance. Children who are age 18 can be included in the assistance unit if they are still in high school and have satisfactory school attendance. And again, Georgia's TANF has a lifetime limit of 48 months. An adult child for the House Bill 499 can apply for TANF and receive TANF benefits if they have minor children in the home. If they are in receipt of child support for themselves, all of that child support will be considered as countable. Any questions?
Thank you, Ms. Newman. Any questions for Ms. Newborn? Well-
Ms. Newborn, I just want to clarify though, I feel like my understanding was it's less impactful on TANF because TANF ends at 18 regardless. So unless that adult disabled child for some reason then goes on to have a child of themselves, of their own, which could happen, but would be rare. Is that fair to say that it would be, of all the programs represented here today, it'd be less impactful on TANF because we're talking about child support after 18, but TANF ends at 18.
Right, TANF would probably be less impactful for the individual because in order for that adult child to receive TANF, they have to be under 18 or they have to have minor children living in the home for whom they are applying for assistance for.
Any other questions? Thank you, Ms. Newborn.
All right, and we have also sort of changing gears a little bit. We have Mara Block, who's gonna, and Mara, you wanna come forward? And she's gonna, again, she was formerly with Atlanta Legal Aid. She is a family practice lawyer in the area of family law. And she's gonna talk to us about impact I know that she saw with legal aid and perhaps other topics. And I don't know if we have anyone else who would want to also address after she finishes, but we'll check in with you then.
Thank you. My name is Mara Block and I'm an attorney. I'm here today on behalf of Atlanta Legal Aid, where I worked from 2017 until 2023. I recently joined the Vetter Law Firm in Savannah as an associate attorney. In my practice at Atlanta Legal Aid, I was appointed to serve on the Statute Review Committee of the Georgia Child Support Commission. This is how I became familiar with HB 499. As I'm sure you know, Atlanta Legal Aid is the largest provider of free legal services to low-income and people with disabilities in the Metro Atlanta region. Every year, Legal Aid assists more than 20,000 low-income individuals and families. Many of those are people with disabilities. It is through this lens of extensive experience working with and for low-income people with disabilities in Georgia that I am here today on behalf of Legal Aid to discuss HB 499 and its potential impacts. First, I would like to note that we appreciate the drafters' desire to provide additional support to adults with disabilities. No one can dispute that it's extremely expensive to provide support for someone with disabilities. Legal aid clients and those who are eligible for our services need money and additional support. One of the real drivers for the need for this type of support that HB 499 provides is that there is simply not enough in the state budget for supportive living and services for adults with disabilities. Second, it's important to understand that HB 499 would impact three categories of individuals: the adult with disabilities themselves, or the recipient of the support, their guardian and caregiver, and the payor parent. At Legal Aid, we advise and represent all three categories of people and do not necessarily prioritize one over the other. In many cases, our clients fall into two or more of those categories. For example, the custodian of a disabled adult is frequently also a person with disabilities himself or herself. As you know, many low-income adults with disabilities receive public benefits such as Social Security or SSI, Medicaid, food stamps, and public or subsidized housing. Support under HB 499, as you've already heard today, for low-income people will be very likely to significantly reduce or eliminate access to those benefits. I won't talk about the details of that because we've already heard from the subject matter experts. It's extremely important to understand that many of these benefits will be immediately or quickly impacted by the receipt of HB 499 support. But if an HB 499 support benefit is not paid, it's incredibly complicated and time-consuming to get back on the benefit. Intermittent or irregular support from other sources can wreak havoc on the receipt of benefits. For example, if an adult with disabilities receives HB 499 support and therefore becomes ineligible for SSI because their income is too high and the payor misses a payment 1 month, there's no way to get SSI for that. The individual would have to reapply and start the process all over again, And that process could, as you heard, take months or years. There's no way to get the benefit quickly or retroactively. And to address something Ms. Lipscomb said earlier regarding putting those benefits in a stable or an able account, yes, the benefit is protected as a resource, so it's not counted as a resource for SSI, but it is still counted as income in the month that it's received. So SSI looks at both income and resources. And in the month that that benefit would be received, it would be considered income for that month, potentially rendering that individual ineligible for the benefit, regardless of the stable account. Second, excuse me. It's also possible that the intended beneficiary's guardian or caregiver's benefits could be impacted. This is especially possible in the case of subsidized housing, where household income includes child support and other regular anticipated amounts. In this example, just getting an order for HB 499 benefits could render an entire family ineligible for subsidized housing, even if the payments are never received. The drafters included language in HB 499 that attempts to protect public benefits. Unfortunately, it is legal aid's assessment that such language is not effective as to any federal benefits. We believe that a special needs trust may, but is not guaranteed to protect the individual's public benefits when they start to get HB 499 support. Unfortunately, this isn't a great solution for most legal aid eligible individuals. First, it requires a special court order. Second, it must be drafted by an attorney, which is costly and time consuming, if an attorney is even available in the county meeting. I would be remiss if I did not mention that most of the civil legal needs of low-income people in this state are not met. Third, special needs trusts can be complicated to administer. Fourth, there are often fees associated with the maintenance of the trust. All in all, the creation of such a trust is complicated and costly at best, and more likely an insurmountable hurdle for low-income clients. I would also like to point out that the language of HB 499 has two differing definitions of qualifying disability. In section 1, the bill refers to disabled children who have attained the majority but lack the ability to otherwise support themselves independently. In section 3, disabled child is defined as an individual who has a physical or mental impairment that substantially limits one or more major life activities, which meets the criteria for disability under state or federal law. Both of these definitions open up support to a wide range of people, not just those with severe disabilities. Inevitably, the question of who qualifies for this support will open the door to extensive litigation for our already overworked Superior Court and family law judges. Finally, I ask that you consider the perspective of the potential payors under HB 499. The harsh reality is that for the families that legal aid represents, there simply is not enough money to support everyone. It is worth considering whether it is fair to encumber a low-income parent, possibly one with disabilities himself or herself, to support another adult for life. Thank you for giving legal aid the opportunity to bring these questions and concerns to the attention of the Commission.
Any questions for Ms. Block?
Quick one, and this is really more on the policy side. My eyes glaze over fairly quickly on the other. Is this bill one, from y'all's perspective, and I know you've been involved with it, is this a bill that is a work in process, or do you think it's a good idea that simply in its present context and form risk being more counterproductive than helpful?
On behalf of legal aid, I'm unfortunately not able to give an opinion as to pending legislation. So I can't comment on that. I'm sorry.
I know Chairman Hitchens out there. Maybe that should be directed to you.
First, any questions for Ms.
This is a
Brown?
work in progress as far as I was concerned. You know, as I said, this is not within the bailiwick in which I typically find myself involved. But what I did was I went to legislative council and told them what I wanted to do. And she said she was unaware of any type of legislation similar. So she wrote it up and I read it. And as a non-lawyer, it sounded okay to me. So I moved forward with it. But I'm very open-minded. And I think, you know, if the commission would like to work with me, I'd like to come up with some legislation if we can, if there's a possibility that would work for everybody. Certainly, that's always the intent with legislation, is to do things that are good for the community as a whole, not just an individual.
Sir.
Thank you, Representative. Any questions for Ms. Block? Thank you, Ms. Block.
Thank you.
Yeah. Instead of taking public comments separately, under item, whatever it is, item 4B, I'm going to take any comments relative to HB 499 now. So Ms. Sapp, would you like to come forward?
I would, please.
Yes.
Do you mind if I stand?
Well, it might pick her up there.
Sure, if you
Yes.
want to go to the lectern, I'm
Yes,
assuming Latana, is that mic live?
We'll find out very quickly. Just go up there and start talking.
Y'all hear me?
People line here.
1, 2, 3. Okay, maybe I wasn't speaking into it. Okay. So I have done a lot of research, and before I even kind of start just giving some of my highlights, Georgia is only one of 9 states that do not carry on for disabled children or disabled adults. So I can give you a list of those real quick also that I have. And that is Georgia, Idaho, Maine, Nebraska, New Mexico, New York, North Carolina, Vermont, and Wisconsin. So they're doing it in other states. So, but anyway, and I'm not saying this has to be across the board. And it may not work for everyone. But what I am saying is, I think a law needs to be passed with everything taken into consideration and based on the situation, right? Some kids might have been getting $700 a month child support. Well, then absolutely this $900 is going to be more and a lot more beneficial. Well, you have other kids who were getting more than that, right? Great deal more than that. And now they're being cut back to this amount of money, right? When I feel like you have, first of all, shouldn't the responsibility fall onto the parents of these disabled adult children instead of all of y'all, right? It's y'all's taxes. And listen, I mean, I have a great heart for this. So I have no problem, my tax dollars going to help people who cannot help themselves. I don't. But I feel like we could have tax dollars help, more of it helping these people or going to other areas instead of y'all now having your tax dollars having to help me provide for my special needs son when he has 2 parents who should and can provide for him. And I know there is conflict on, well, the Medicaid and the different things like that. So I know it's a lot, but I just feel like something has got to be done on this. And I'm really shocked, honestly, that nothing has been done before. And I have a lot of people who figured I would always get child support because of my son being disabled, that they didn't even realize that you don't, that he basically emancipates. Well, a disabled adult child is still a dependent. He is a dependent, just like a child under 18 is. So when you divorce, Georgia law believes in child support. Okay, that child should have all their needs and everything taken care of them, right? But then how can you say, oh, well, now they've turned a age and you no longer can support them? That to me is just, I just don't understand. So anyway, let me just get off of that because I'll rattle on. But anyway, so disabled children grow up to be disabled adults. Fact. Disabled adults are still a dependent and always will be in most cases, right? But I feel like we now have the opportunity to shift who they are dependent on in many cases, right? I feel like emancipation should be based on one's ability to provide for themselves. Rent, utilities, food, necessities, transportation. Emancipation should not be based on one's chronological age, right? Emancipation is because at 18, you can go out, get a job, work, pay rent, pay utilities. These disabled kids cannot do that. They'll always be a dependent and they will rely on their parents. And what if you're in a divorce situation and one parent is like, whoo, then you have the one parent left. Now, what if I did that? I could never do that. But what if I did that? He falls completely on the state to take care of him, which is more tax dollars. And where would he go? I mean, I guess like a state home somewhere, an institution. I mean, I don't know. So how in the eyes of the law can only one parent be responsible financially, emotionally, physically, spiritually? These things we all know are what encompass caregiving. When two parents are legally responsible for creating said child as acknowledged in the divorce paperwork and acknowledged by the court. Why is it now just one parent's responsibility when that child is disabled? Unburdening the parent who has taken on the responsibility by engaging as both parents in all the ways I mentioned would help relieve the parent that showed up and who is doing their part to help enable the disabled adult child to be an active part of society. Because I want that for him, right? I'm working with vocational rehab right now. So we can find him a job several days a week, several hours a day. He needs to be productive. He can't stay home all day, every day, and he can't go to work with me every day. He does go with me sometimes to the office. I don't leave him at home all day by himself. If I'm showing property, he rides in the car with me. Car stays running. He locks the doors. I go inside, show a house. I come back. My son is now, he's 20. Okay. I have a 28-year-old daughter. She turned 28 in June, neurotypical. My son just turned 20, the end of July, graduated high school, neurodivergent. So I've seen both sides, right? So my son's every need depends on me. Everything. Honestly, I've always said the child would die without me. I do it all. A single parent of a disabled child or a disabled adult child struggles holding down a job or any employment that pays enough to support two people. So let's keep in mind, we have to drive them to and from therapies, drive them to and from a job, schedule all their appointments, drive them to their appointments, wait on them, pay, and drive them back home. We drive them for their every need and want, and the majority of all these things take place between 8 a.m. and 6 p.m. And we have to work, and we have to make enough money to provide for the two adults. That's a lot. So he's in ABA therapy. Well, the year prior, I took him to school at 8:45, had to be back at school at 12:20 to pick him up, drive him all the way to Richmond Hill for therapy at 1 o'clock, and be back in Richmond Hill to pick him up at 4:20 and work. It took 3 hours out of 2 days a week of me just commuting him. And I have to work. So luckily, What I do, I can work at midnight at night. I work late at night. I mean, you know, that's just what I have to do. I work all the time. So I feel like a law needs to be passed where a disabled adult child can receive financial maintenance from the non-custodial parent. Let me show y'all this. So I just have this in my work file because I just gave Brett a graduation party and I was printing out a picture, make like a little poster thing. Anyway, so here is a picture of my son, his graduation, his senior picture. Okay. Autism has no physical defect. None. So Brett had his last psychological evaluation earlier this year. The report was dated April 25th. This was his diagnosis. Specific learning disorder with impairment in mathematics and calculation and mathematical reasoning, severe. Specific learning disorder with impairment in reading comprehension, severe. Autism spectrum disorder without accompanying intellectual impairment requiring substantial support. He is the best kid, and I don't want to get upset because I can very easily. I love this child immensely, and I'll do anything in this world for him. He is the sweetest kid. And everyone, if you've met one person with autism, you've truly only met one person. They're all so different, right? That's why there's this spectrum. But Brett is social, like he's had to be taught everything. And we started ABA when he was a little over 3 years old. We had someone come in our home 4 days a week, 2 hours a day. He had that for years. Then we divorced. I was a stay-at-home mom. We divorced. I had to start working. So the therapy basically stopped. Well, we just got him back into this. Well, I started him in one therapy he's been in it for about 8 years because I could afford it. Well, had another psych eval and she said he's got to get back into ABA therapy. We got him into this, and it's really what has made him who he is today. He had to learn everything. Like, this is what a kitchen is, things that kids just pick up on, right? So this is what a bedroom looks like. So when he saw it in other places, he would know. This is beside, this is on top of. I mean, pronouns, things kids pick up on, he didn't. And he's social, but his social, I mean, like if you were to talk to him, you would know within a minute or two. And he talks about things, his social skills are just low. He's very immature for his age. And we're trying to get him, I want to whatever level he can get to, right? I want just the best for him to whatever. I will not be here one day. So anyway, and Dr. Duke in our consult review, said that she did see some areas of improvement since her last psych eval, right? Like he was giving more eye contact, and whenever he didn't know something, a question, he was like in the first, 3 years ago, he was like, why are you asking me that? I don't know. And now in ABA, we've tried to let him know, listen, things don't always go your way and it's okay. And she could see some of that with him that was much better. Anyway, so basically, you can see what we've been able to do with the court's order, right? During the child support with this child. So imagine what we could do if the court had the decision to continue financial support or financial maintenance for kids like this. His ABA therapy, we got him into it, and under his dad's health insurance, the copay's $70 a day, $540 a month, okay? Well, now with his dad stopping his health insurance, it's going to cost me almost $4,800 a month. Now, I can't afford that. I was picking up the $70 a day, okay? Or So anyway, and I know under Medicaid, I think you can get some ABA therapy. Okay, they'll take care of that. And so I know there's a bunch of different, it's a lot. I mean, I just know it's a lot, right? But there has to be some ways to make this work. And like I said, they're doing it in other states, and they actually are saying that it is the parents' legal and moral right or what they should have to do. I mean, I know I'm a little nervous up here, but that the state looks at it as legally and morally, it is the parents' responsibility. This should not be put back on the state as their responsibility. So I feel like in all cases, this won't work. But I feel like a law should be passed where a custodial parent has the right to approach the courts, and the judge has the discretion to grant that. And it won't work for everyone. And I'm not saying in all cases, but there are a lot of cases, I'm telling you, that it would help tremendously for these kids. So we've got to find some ground to come together on this. Does anyone have any questions or any comments or anything? I've not covered a lot of the stuff, just because I don't have long up here. But like I said, they are doing it in other states. And ABA, it's applied behavioral analysis therapy. Yep. So, because basically, you know, it's even, I have something here where it says the sufficient means standard is described by case law as the likelihood the child will become a public charge, right? And that's what happens. I can email you over that. Okay. Yeah. I have a lot of documentation. I've been researching this stuff for like 2.5 years.
My business card is on that table as you first came in.
Okay. Okay.
We appreciate you being here. We're in the listening stage right now, trying to understand ourselves. As everyone sees, it's a very complicated issue. I've been a juvenile court judge for 34 years, but I was part-time 7 years ago. So 30 years I did divorce. And yes, I saw these cases from both sides, from the child age staff, but child support. I certainly understand.
Right, because they're still a dependent. Right, you know, because how can they emancipate, right, when they're still a dependent? That's the whole question. Thank you.
The public comments, we will log in once we're posted, watch the rest of you do. Thank you for being here. I know you have previous obligations, but thank you.
Chat for folks to post the names if they want to public comment.
Yes, and yes, Ms. Lipscomb, you may.
Excuse me, I need to take a correction. I misquoted the exclusion on the stable account. I apologize. It's $100,000. I apologize. I thought it was wrong and I looked it up, but it's 100,000. So 125. So I apologize for that being misinformation.
Thank you. Let's take any public comment on this on 499 for people in the room right now. Is there any public comment on House Bill 499? Is anyone on?
I guess I completely understand what you're dealing with. I know that we need solutions. My concern is this a bill for the child support guidelines statute? Or is this something that needs to spring to life in its own piece of legislation independent of the child support guidelines bill? An extension of it somehow, and the legislators would certainly need to answer that maybe more, because I don't have the answers for it, but it seems like it's larger than life. There are so many aspects and components involved in this. There's everything that we have to consider about folks who are low-income families dealing with this situation. Everything that's been spoken to here today from our subject matter experts. There's just so much that needs to be looked at and thought about. It just seems like it's more than just putting a little provision into subsection E of 19615, or even with a definition. And should it be part of 19615, or should it be studied, and should it be in another piece of, should it be in another part of the code? I mean, I don't know. Because Division of Child Support Services will have nothing to do with this because these kids have aged out. So, and about half the cases in Georgia that are using 19615 are DCSS cases. And so you're really talking about cases that are private and right. So, and that's my comment, but I think that, did you have any other questions or anyone else to make comment? I mean, that was my comment. That's my concern.
Yeah.
1 minute comment.
Okay, right, it basically would be now turned into like financial management, right? Not child support, financial management. So right now, I could not petition the court, right? And see everything together and see. Because there's no statute. So there, a judge would not say, in his mind, he'd probably say, oh yeah, he needs to do this, right? But he won't do it because there's no statute where he can fall back on to say he has the right to make his father help me support his son, our child, you know. So that's where the problem is. So something needs to be done. And like I said, it doesn't need to be across the board. It's not going to work for everyone. But there are a lot of people out there who could help provide. They're both parents and the non-custodial parent. So, but I can't petition the court for that right now. And that's what needs to be changed, where there is some sort of law where that can happen. I feel like.
Well, like I said, this is much larger than just what the Child Support Commission can do. So we're certainly will continue to look at it, and we would be part of trying to understand its impact on what is within our purview here. So how many people do we have that want to make comment of any sort at this point?
Yeah, we have Bill Freeman who wants to speak on 499 specifically, and then we have 4 other people.
So we have 5 people. Is that, do you intend to speak, sir? Anyone else in the room intend to speak today?
Oh, not, excuse me, not specifically on that bill, no.
So, trying to calculate how much time I can give people, so.
Yeah, Tracy Palma Doran had contacted me by email asking to speak today, and is she here?
She is, and I got her.
She's
one of the.
She's one of them.
Right.
Okay.
We're going to do 30 not seconds, but we're going to do 3 minutes per public comment. I'm sorry, I wish we had more time, but we don't. So we're going to do 3 minutes, and let's start with anyone here going to speak to 499. All right, who's your first person that wants to speak?
The man that's specifically on 499 was Gil Freeman.
Gil Freeman, are you there on Zoom? Gil Freeman? Yes, I'm starting my timer. 3 minutes, please. Thank you. Mr. Freeman. Mr. Freeman, thank you very much. Thank you for your comments. We appreciate that. Any other on 499? Noelle?
I don't think so.
All right, sir, you have public comments?
Sure.
Would you step up, and sit at the table, please?
Sure. Well, if it's okay, I can step up to the podium.
Sure.
And your name, please?
My name is Brian Ellis. So, just to advocate for fathers, just based on, I know a House bill that was talked about before, which is Georgia House Bill 96 for 50-50 custody as a standard for divorces. Just because, just like Mr. Gill said, a lot of divorces, 70% of divorces are unfortunately brought on by the women. And I feel like it's been incentivized for almost like the destruction of a father. And also, you know, child support, I know currently is based on gross pay, but none of us see gross pay. If you looked at net pay of what the father actually took home and based child support off of that, I think that would be more advantageous to both parties, just because a lot of times, a lot of people, like for myself, I can only speak for myself, where I'm paying child support based on gross pay. I did not want to only have 30% of my child and pay 70% of all of their necessities. So if it was based on net pay, I think it would be better. But also, I think if it was a standard of 50-50 from the divorce, then I feel like that would have been, I would have been more on even ground as far as that goes. Because a lot of fathers, we are not absent fathers. We want to be there. Me personally, I've been with my son's school. My son is 4 years old. And with my son's school, I've been on all of his field trips except for one, just to spend extra time with my son. I do above and beyond. I buy school supplies, you know, the whole 10 yards. And I just feel like, you know, during mediation, it's unfortunate that my own attorney and the mediator basically turned against me and said, there's no way that you can get 50-50 of your son. And if it's that, if House Bill 96 is able to be brought back up, and if it's passed, then allow those fathers to appeal their own custody agreement to the standard of 50-50 custody. And that's all I want to say. No problem.
You want to speak? You want to speak? Yes. What is your name, please?
My name is Nika Lagon.
All right, you may come forward. Start the timer.
Thank you. And to the executive, Ms. Celine Johnson, you might get a voicemail from me. I was looking for parking, trying to get in here. So sorry, deleted. But thank you all. Just to give you a very brief background on why I'm here. I sent an email to my Senate Minority Leader, Gloria Butler, and her chief of staff called me. We had a meeting to discuss, you know, the child support worksheet issues that I had been experiencing and just the systemic issues I had experienced, you know, with the courts and the whole, you know, system. I'm a mother of two. And I live in DeKalb County. And then he spoke with Miss Noelle, I believe, about the issues. And she, you know, I was told she invited me to have a different perspective, you know, on this topic. So that's why I'm here. And I'm hoping that this will give you a human, you know, face, another face, you know, and perspective to the issue of child support. The chief of staff, Ross Harris, is you know, still talking with Gloria Butler, the Senate Minority Leader, about you know, increasing the budget to the Women's Resource Center to help there, and also, you know, having more legal resources for, you know, single mothers or mothers who have suddenly, you know, gone through a divorce, separation, and, you know, nobody asks for this. I believe in the dream of, our founding fathers of this nation. And what I have seen in the courts and through the system, as far as accountability and equity for our children, is not what I think they thought. Many mothers are going through the same thing as me, insufficient, child support, arbitrary child support amounts that are awarded. I've been told by, a lawyer at the Child Support Services, at a point that, $50 should be enough, sufficient for 2 children, per month. So all of this just perpetuates, financial abuse. And I brought this here. I don't know if you can see it. But obviously, I'm not expecting you to read through it. But I brought that just to show the trajectory of, the courts, the things I filled out, how I've been going about it. And the red dots on that show how the financial abuse increases all the way from separation to now, going through a divorce. But the financial abuse just continues to increase. And the funny thing is that the child support, worksheet, they always seem, they're hardly looked at. They haven't been looked at in any of, my court. The court system, they're way down. They're doing a lot. I really appreciate all the work. I've met nice people, right? This is not about the people there. It's about the system, and the worksheets are hardly looked at. My child support amount is arbitrary. And I was told that, it always seems difficult to pull up the worksheets in court. It doesn't show the current or, submitted copies. It shows incorrect amounts. And in fact, at a point, a judge awarded an incorrect amount. They corrected it right after, but, those are the types of things we face. So, even the lawyers that I've spoken with, they seem resigned to the flaws, in the worksheet. Things like the yearly income suddenly showing up as, monthly income, throwing off the judge, in the court. And so all this doesn't, help when we're going through this difficult time in our lives. We're grossly overlooking the financial abuse, when we ignore these things, or, even maybe, and I know the commission is probably working so hard at this, but, the quickness to which we solve these issues is affecting lives. And so I just want you to know that as you work to fix these issues, it affects real lives like mine. I sometimes wonder if I would have, lastly, I sometimes wonder if I would have the strength or the funds to even walk in with that poster board if I was made destitute by, what my spouse had done and using the system, the financial abuse, evading, court orders, disregarding them, all of that. I wonder if I would be able to come in and even buy that poster board. I wonder if I would be in a shelter with my children, I took my children recently to see the Barbie movie for nostalgic reasons. And so I wore pink earrings here today to remind me. There was a line in the movie and I wasn't expecting inspiration from the movie, but it said that, I can't fix everything, but maybe I can go back and fix one thing. And that's what I'm trying to do here, is just lend my voice to this and know that mothers, I'm specifically saying mothers, because I've spoken to a lot of mothers like me, are going through a lot in the system with just trying to get equitable child support and to get the child support worksheets looked at correctly. So thank you very much for listening to me.
Yeah.
Ms. Tracy Palmer Doran.
Ms. Palmer Doran, are you with us by Zoom? Oh,
Latana will bring her over.
all right.
Okay. Good morning. Can you guys hear me?
Yes, I'm starting my timer. It's not ringing, so I'm gonna have to cut you off, but please go ahead.
Okay, no worries. So good morning. And I have attended many of the Child Support Committee hearing meetings. And I would like to comment on the previous woman's, and I'm sorry, I forgot her name, issue. I want to say that I can empathize with her, but this is not a gender issue. This is an issue with the family court system itself. I happen to have a brother who's going through the same thing. He brought home a $17.40 paycheck after paying all of his child support. Now, I would like to know how he, as a loving father, he's involved in everything his children do. He goes to all the sporting events, all of the school events. How is he supposed to even buy gas to get to work with a $17.40 paycheck? So I want it to be known that this is not just a mother or a female issue. This is a bipartisan gender. It's not a gender issue. It goes both ways. We're all here because we love children and want what's right for them. We, the public, have a hard time accepting some of the items that this Child Support Committee hearing recommends because they violate several of our rights under the Constitution. 2 or 3 being due process, equal protections, and freedom from excessive fines. Everyone who's on this committee has took an oath to uphold and protect our rights under the US Constitution. We are simply asking that all of those rights, both for men and women, mothers and fathers, be upheld as long as they're fit and willing parents. We rarely hear about a custodial parent being held accountable for interference with custody, but it is criminal in Georgia. And I know that you guys are all familiar with the code, OCGA 16-6-45. However, if a non-custodial parent is unable to make a child support payment because they simply do not have the means, they get thrown in jail without due process. I am praying that you all do the right thing and uphold the oath that you took to protect our rights and our children's rights under the US Constitution. Thank you for your time.
Thank you so much for your comments. Now, let me remind those persons making comments that the commission deals with policy and law. A lot of what we've heard here today, it seems to be the public comments relates to practice. It's actually done in the courts themselves when you're out there. So we do thank you for your comments, and the courts are represented on the commission. Who's our next person for comment?
There's somebody just identified as Elizabeth.
Elizabeth?
Yes, sir. My name is Elizabeth Murphy, and I am an attorney in Savannah that practices family law and estate planning. And I'm here on behalf of Ms. Jill Sapp. And I understand I'm on a timer, so I will make this as brief as possible. And I will also agree with Ms. Palma Doran. It is not a male-female issue. It is a caregiver's issue. And I have seen this happen with female parents and male parents, both being left responsible for a disabled child or a disabled adult, excuse me, which Black's Legal Dictionary defines as a person of legal age who has a temporary or permanent physical or mental handicap. And that is what we are talking about here. We are talking about an adult that has emancipated, so to speak, been released from the control, support, and responsibility of a parent or guardian that cannot take care of himself. So we are passing that person over to the state as a ward, which is defined as a person, usually a minor, who is under a guardian's charge or protection. So we are saying that anybody that has a disability as defined under the law should be a ward of the state. That is not correct. If a parent has a means, we are not saying all parents, we are saying if the parent has the means to pay for their adult child's disability, whatever that means for care, if that means OT, occupational therapy, or behavioral therapy, or speech therapy, whatever that is, we're actually adding value to the economy by doing that. We're putting this person in a position that's not taking away from the state. We're not trying to take funds that are there for those that don't have the resources. But if there is a parent or a natural guardian that has the resources, they should be required to support someone that is legally not able to take care of themselves. We are talking about people that have conservators and guardians appointed by the court. So if the court finds that these individuals are unable to take care of themselves, then I understand why discretion is so scary for people. But the discretion of the judge in that case should be the ruling factor. That's what we're talking about. The judge being able to look at the circumstances of the case at hand, not a blanket application of the law, but the judge's discretion to ensure that the child, disabled adult, however we're referring to this individual, does not become a ward of the state, but is actually just taken care of by the natural parents. And, you know, and I understand that going above and beyond for some people is buying school supplies and doing field trips. That's being a parent. That is showing up and being a parent. And your duties as a parent don't drop off when your child turns 18. Your duties as a parent don't drop off when your child turns 40. Your duties as a parent, they end when you leave this earth. That is when your duties as a parent. And you know that when you have a child.
Thank you, Elizabeth. Do we have others signed up?
We do, we have Mr. Anton, but he has had to drop off the call. We now have Charles Launch.
Charles.
Launch.
Do it, Charles, and
Yeah.
Tony. Charles, you may proceed. 3 minutes. Charles, are you there?
Yeah, I'm here. Can you guys hear me?
Yes.
You guys can hear me?
Yes, please go
Okay,
ahead.
I just wanted to make sure. I certainly don't want to ramble with nobody hearing me. Well, I wanted to speak quickly about incentives. I've looked at the report that Dr. Venor put out. Using median income data of the custodial and non-custodial parent, it looks like the custodial parent is median income is $21.85 per month. The non-custodial parent's $26.20. To put that into perspective, custodial parents are making about 50% of the median wage in the state of Georgia. For non-custodial parents, that is about 60.9%, so say 61%. So why are they continually pushing their income down, or why are they not able to make that income? What appears to me is if you're the custodial parent and you get an increase in your income, you are going to, by the child support guidelines, get a reduction in your child support. You may lose your child tax credits, your earned income credits, all those type of credits, and maybe even some additional government assistance. Likewise, if you're the non-custodial parent, you increase your income, you're going to, of course, pay more taxes. And then you're also going to subject yourself to a higher child support amount. So in essence, you get an extra $200-300 a month, and they're going to take the vast majority of that just in taxes and child support. Well, I can empathize that to the custodial parent, they always think that they're not getting enough, and to the non-custodial parent, they always think that they're paying too much. Once we factor in the taxes that are afforded to these two people, let's say there's 2 children, they're going to be paying $693 per month based on the median income. And then, so for the non-custodial parent, they're also going to pay an extra $389 a month in federal and state taxes. So the median non-custodial parent is only bringing in $1,538 a month to support themselves. Now, the custodial parent gets a net tax credit of $451 a month, plus the $693 in child support, plus, of course, the income, leaving a net of $3329 per month. So you can see why nobody wants to increase the amount of time or the wage that they're earning. I mean, I would encourage all of the members of the committee to spend 1 year supporting themselves on that $15.38 per month. The median rent in Georgia is $12.93. In Atlanta, that number is $18.46. And report back to us on how that was. You know, make sure that you're paying rent, make sure that you're paying all your expenses. The problem with House Bill 499 is the problem that there is with the guidelines in general. You know, the economic impact of this is everybody is trying to push their wages down, and House Bill 499 extends that on for basically a lifetime of wanting to reduce your income. So both the custodial parent and the non-custodial parent are reducing their income, reducing their tax burden, reducing their child support burden by keeping low income jobs. Maybe they're selling drugs or doing something to support themselves, because I don't understand how anybody thinks that this person is able to live on almost none of their income.
Thank you, Charles. We appreciate your comments.
Thank you.
That concludes all of our public comments. I do want to say that more I listen to the comments around this. The 499 is a fascinating subject to me. That's a very substantial public policy decision that has to be made by the legislature. And if the legislature makes the policy decision to extend the obligation beyond where it currently exists, it would be our responsibility then to put the child support infrastructure in place to allow that to take place, to award amounts, whatever however they're labeled, if we're called on to do it, it results in appropriate awards of child support or maintenance for the children or the adults with disabilities involved. But it's clearly a public policy decision not to be made by the commission, but being made by the legislature. We stand ready to play our part in helping carry that out if the legislature makes that public policy decision. And with that, our next meeting is November 17th, 10 a.m. Most likely here. Again, it'll be Zoom and in person. This is going to be a very important meeting. We'll be addressing some specific legislative proposals. So we encourage all of our commission members and all those interested in the public to be here for that. All right, thank you all.
We adjourn.
We stand adjourned.
Thank you.
Thank you.
Recording stopped.